from the second list of 215, serial number 58.
58. What is it all
For
about?
final. It is for final hearing.
Yeah.
The small matter is that the interim order of the Labour Court Dhanbad has been challenged, where the permission to file an amendment petition has been allowed. That has only been challenged in this
What the respondent?
There is stay has been granted.
आप interim order भी आ जाएगा?
Yes, and there is a stay in my favor.
So?
He wants an early hearing. We are consenting for early hearing. इसको Monday को early hearing.
What is the nature of stay? What is the nature of amendment?
Amendment to the terms of reference. Earlier
The
reference.
court can
earlier.
just a moment. The
earlier,
court can amend the terms of reference.
The court has amended the terms of reference without following the procedure enshrined under section. Just a second, brother. Let me conclude. Section 10.
इतना लड़ने का नहीं है.
Section 10 में जो process होना चाहिए था conciliation करके amendment करने के लिए, उनको follow नहीं हुआ. उन्होंने amendment कर दिया. उसी amendment के order को हम लोग यहाँ read petition में challenge. बहुत छोटा सा order है, 2 page.
In the written statement, we come to know that the petitioner was applied his challenge his transfer order has been dismissed. In the written statement, we came to know that, not prior that. So,
amendment नहीं हो सकता.
Your Lordship, after that we have moved the process of conciliation, and after conciliation we again moved before the Labour Court, and that's why the application has been allowed for amendment. Also, it may be our pleadings are complete, Your Lordship. It may just
yes, that's why we are also concerned. 2 page का order है, छोटा
Section
सा.
33 लगता है?
नहीं, 33 इसमें नहीं. Section 10 reference है तो section 10. वो connected, not connected, वो उसमें.
आपको fresh reference कराना चाहिए.
fresh reference dismissal के लिए fresh reference के लिए गए हैं, और एक termination के लिए भी fresh reference के लिए गया हुआ है, तो वो दोनों orders.
ठीक है, let us see. Monday नहीं, हम लोग का इसका labor matters का सिर्फ एक ही दिन है. 27. That is on Thursday.
तो एक छोटा सा request है. 27 उसको supply list में रख दिया जाए. कितना?
क्यों नहीं 10 बजे का list में रख देते हैं?
आप जैसा honorable court
record आया है?
Records
जरूरत नहीं.
आया scan बचा है.
With the consent of the right counsel for the parties, pose this case on next Thursday for final disposal to be taken up at first case. आप notes बनाए हुए दोनों. नहीं तो नहीं सुनेंगे, adjourn कर देंगे. Counsel for the parties are also directed to prepare to furnish written submissions along with judgments which they are seeking to rely upon prior to the next step. और कौन सा mention करना है?
Serial number 44.
क्या है?
Only period it may be listed along with petition number 368 of 2008.
Why?
Labour Commissioner passed an order that contract labor be regularized. Thereafter, they have challenged in 2008 that order, and there is a stay. On the pretext that it is jurisdiction of the Central Labour Commission. I approached before Central Labour Commissioner. He said until disposal of that order, we cannot do anything. That has been challenged in the press.
Other side कौन है उसमें? मेरे board का है?
Yes.
Is it delisted?
No. Presently, a new case I filed, which is listed today, serial number 44. My only query, it may be listed along with that petition 368 of 2008.
368 to 2008 is admitted case.
No, it is not admitted, but there is a stay order.
तो देखिए तो 368 2008 का status. WPL.
WPC.
ठीक है WPC. नहीं तो हम नहीं लिस्ट कर सकते हैं.
That is labor matter.
Maybe labor matter. WPC करके फाइल किए हैं तो WPC में मेंशन करिए that it is a labor matter. Get the nomenclature changed and then only it will be listed over here. I will not change the nomenclature like this. You file an IA.
I have filed IA.
IA in that WPC that the nomenclature is incorrect. कुछ उस स्टेटस से क्या होगा? WPC हम नहीं लिस्ट करेंगे. नहीं. हम कर ही नहीं सकते. आपको उपाय भी बता दिए क्या करना है.
Serial number 28 from the list.
Yes.
It is a labor matter. It is very small matter, madam.
No matter is small. What is it?
My petition has been dismissed for default for non-compliance of the order of the learned.
Dismissed for default.
That has.
Okay. Who's for the other side? मिस्टर निपुण बख्शी, आपका कोई केस डीएफडी हुआ आज तक?
नहीं नहीं मेरा नहीं, अदर साइड का वहाँ पे डी
आप नहीं, हम ऐसे पूछ रहे हैं, कभी हुआ है आपका?
नहीं हुआ है।
हुआ है ना, तो इनका भी केस डीएफडी हो गया, रेस्टोरेशन के लिए तैयार हो गए।
नहीं हम ज्यादा अपोज भी नहीं।
चलिए 4 बजे
28
फाइल मंगाइए 4 बजे।
28
20.
अब आपका क्या है?
Lord serial 3 minute. First appeal matter is Lord remember that case.
अच्छा, गार्जियनशिप।
Actually, it may kind of be done. Lord other side has been asked to Lord inform the court about the modality.
Have they come?
Intimated, but they are not here. Mr. Ranjit Kumar is fighting election.
Oh, he's busy. तो कॉल होने दीजिए तभी ना, ऐसे कैसे होगा? चलिए कॉल करिए। पहले तो एक पासओवर मैटर, somebody has joined.
ये पर्सनल अपीयरेंस के लिए था।
हाँ, yes.
एक्चुअली डायरेक्टर
Passover
प्रोफेसर
to
अभी लीव में है,
24.
मेडिकल लीव में, उनके जगह पे जो इंचार्ज में है वो करेक्ट।
May I know your name, please? I can't hear you. आपका नाम क्या है? आपने आपको अनम्यूट करिए प्लीज। आपके पास कोई टेक्निकल असिस्टेंस है? उनको बोलिए आपको अनम्यूट करना है। हमारी तरफ से अनम्यूट करना है। आप अपने किसी टेक्निकल असिस्टेंट को बोलिए आपको अनम्यूट करना है। आवाज नहीं आ रही।
आनंद कुमार लकड़ा, डिप्टी डायरेक्टर
आवाज
प्रोसेसिंग।
कम। ओके, आप हमको एक बात बताइए, इन दिस बेल एप्लीकेशन, राइट, there were numerous crime links, 14 crime links, correct? And in the portal it was showing that there are how many FIRs? 10 FIRs have been lodged.
Para 33.
Right, in para 33 of the case diary. So their bail application was rejected earlier by saying that there is 10 FIR and so many crime links, so I rejected their bail application. They have now filed a fresh application saying that no FIR has been registered against them. So we called for a counter affidavit. The person who has filed the counter affidavit in his report has verified only 3 crime links and has said that there is no FIR lodged. So what about the other crime links? 11 crime links. And in the portal, I'm sure that you know as to from where these crime links are coming. So this inquiry is absolutely incomplete. आपको मेरी बात समझ आई?
Actually, this is from the concerned SP.
No, that's right. But the point is that you are the nodal body and this is not the solitary case. आपको मैं बताऊं, ये इकलौता केस नहीं है। आपके पास क्राइम लिंक्स रहते हैं, पोर्टल में दिख रहा है कि 10 FIR फाइल हुआ है, ठीक है, लेकिन आप इंक्वायरी नहीं करते हैं कि वहां पे 10 FIR कहाँ क्या फाइल हुआ है। पिटिशनर बोलता है मेरे अगेंस्ट में तो कोई FIR रजिस्टर्ड ही नहीं है। तो आपका जो इनका जो बेल एप्लीकेशन प्रीवियसली रिजेक्ट हुआ है उसमें रॉन्ग सबमिशन हो गया ना आप लोग का।
This is about the police department.
So you are representing director prosecution, isn't it? You are at the nodal body.
Some जो है वो पुलिस का है, और इसमें मैं बात करूँगा डिफिकल्टी बात है।
देखिए ऐसा है ना कि अगर इस तरह का काउंटर एफिडेविट हमारे पास आएगा तो हम तो उनके ऊपर कंटेम्प्ट प्रोसीडिंग शुरू कर देंगे, ठीक है, कि आधी बात वो बताते नहीं है और इस तरह का स्टेप हम लोग लेना नहीं चाहते, इसीलिए आपको खबर कर रहे हैं।
मैं करना करूँगा डिफिकल्टी बात को, और उनसे वेट करके मैं इसको सॉल्व करता हूँ।
ठीक है, कंप्लीट पिक्चर आना चाहिए। और ये सिर्फ एक केस का नहीं है, और केसेस का भी है जिसमें एफआईआर दिख रहा है, तो आप पता करेंगे ना कंसर्न पुलिस स्टेशन से कि एफआईआर रजिस्टर हुआ है तो केस नंबर दीजिए, राइट। और दूसरी बात ये भी वहां पे करेंगे कि भाई इनको रिमांड पे लीजिए, नहीं करेंगे
इन्फॉर्म करना चाहिए।
तो फिर बॉल एक दूसरे को पास करिएगा तो दो चार लोग को कंटेम्प्ट शुरू कर देंगे ना, कंटेम्प्ट तो हम प्रोसिक्यूट भी कर देंगे कंटेम्प्ट, मैं आपको बता दे रही हूँ। दिस शुड नॉट हैपन। इसमें सप्लीमेंट्री एफिडेविट फाइल कराइए। ये जो प्रीवियस सबमिशन हुआ है ना, इसको आपको जस्टिफाई करना होगा, नहीं तो हम तो इनको बेल देंगे ही, उसके बाद आपसे बात करेंगे। और आपके जो भी आईओ हैं, मान लीजिए किसी कारण से पोर्टल में दिख रहा है एफआईआर लेकिन एक्चुअल में इंस्टीट्यूट नहीं हुआ एफआईआर, तो बोलेंगे ना कि सारे एफआईआर जो भी दिख रहे हैं हम उनसे वेरीफाई कर लिए हैं, इतना जगह हम वेरीफाई किए और कोई भी एफआईआर इंस्टीट्यूट नहीं हुआ। ठीक है, इसका मतलब पोर्टल में गलत फिगर दिख रहा है, पोर्टल में गलत इंफॉर्मेशन दिख रहा है, तो वो भी तो रेक्टिफाई करने की जरूरत है ना। अगर एफआईआर दिख रहा है और एफआईआर रजिस्टर नहीं हुआ है तो बहुत सीरियस बात है। फिर तो हम भेज देंगे होम मिनिस्ट्री को कि अपना पोर्टल ठीक करिए, मिसलीडिंग है पोर्टल। फिर अपना यूनियन ऑफ इंडिया के होम मिनिस्टर समझेंगे उनको क्या करना है और क्या नहीं करना है, फिर आप जानिए और वो जानिए। ठीक है,
मैं देखता हूँ।
और एक बात आपके साथ शेयर कर रहे हैं, जैसा पता चला है नॉर्मली जो सीजर होता है, मोस्ट ऑफ द टाइम सीजर विटनेसेस आर द पुलिस ऑफिशियल्स ओनली, क्योंकि जंगल मंगल में जाके सीजर वगैरह करते हैं। ये कोर्ट में जाके हॉस्टाइल कैसे हो जाता? अगर फोन का सीजर से हॉस्टाइल हो गया विटनेस तो खत्म कहानी, राइट। काफी एक्यूटल है आपके यहाँ साइबर क्राइम का। आप देखिएगा कितना परसेंट एक्यूटल है, 50%, 95% एक्यूटल बिकॉज ऑफ द पुलिस ऑफिसर्स। ये कोई छोटा मोटा फिगर नहीं है।
मैम ये इन्वेस्टिगेशन का पार्ट है, मैं कन्वे करूंगा डीसीपी मैम को। और
भाई जो भी प्रक्रिया है सीजर का, सर्च का, पुलिस वाले खुद ही विटनेस बन रहे हैं। और कोर्ट में एक आध केस में तो कोर्ट में जाके बोल रहे हैं हमको पता नहीं है कि कौन सा, क्रॉस में बोल रहे हैं हमको पता नहीं है कि जो मोबाइल सीज हुआ है उसका IMEI नंबर क्या है, हमको पता नहीं है कि उसका मोबाइल नंबर क्या है। ऐसा क्रॉस में आ रहा है, आपके पुलिस ऑफिसर का क्रॉस। कोई राह चलते आदमी का क्रॉस हो तो समझ आता है। एवरीथिंग इज नॉट फेयर, डज नॉट अपीयर टू बी फेयर। 95% एक्यूटल बहुत होता है। और एक्यूज को पता है सीजर तोड़ दिए तो बात खत्म है, क्या सीजर ही तो तोड़ना है ना। लेकिन इसका आप सप्लीमेंट्री एफिडेविट फाइल करा, ये कौन फाइल करेगा खाली इतना बता दीजिए, हु इज द अथॉरिटी हु विल फाइल इट। क्योंकि जिसने फाइल किया है उस पर तो कोई ट्रस्ट नहीं हो सकता। एसपी से करें, एसपी को बोलते फाइल करें, ठीक है। चलिए यू कैन discontinue and I'll pass an order. Okay. Heard the learned counsel appealing on behalf of the parties.
Actually, lordship please उनको क्लोज कर
आप ऑफलाइन हो जाइए,
ये कर देना, ऑफलाइन कर। एक्चुअली हो रहा है कि हर थाने में एक क्लर्क की हर थाने में होमगार्ड या जो लिटरेट क्लर्क होता है जो डेली वेजेस टाइपिंग करके होते हैं, उनको कंप्यूटर ऑपरेटर पे लोग बैठा, वही जो इन्वेस्टिगेटिंग ऑफिसर होता है उसके पास जाते हैं कि ये केस का एक्नॉलेजमेंट नंबर डाल के मेरा पोर्टल से डाउनलोड करके चार्ट, वो जो चार्ट देते हैं चार्ट के अनुसार ये लोग एक कॉरेस्पॉन्डेंस करते हैं एसपी ऑफिस को, या नहीं तो जो टेक्निकल स्टाफ रहता है उसको, उनके पास से जो रिपोर्ट आता है उसको रिपोर्ट को ये लोग देखते हैं, कोई आईओ उसको कंपेयर करते हैं, कोई आईओ उसको इनिशियल मार्क उसको। ये इंटरनल भी अपने सोर्स से होता है ना कि आखिर हमारे साथ ऐसा क्यों आ रहा है। तो हम बोले कि आप जो उस स्टाफ को बिठा के रखते हैं उसको कोई मॉनिटरिंग करने वाला है कि वो स्टाफ राइट कर रहा है कि रॉन्ग कर रहा है। और जो स्टाफ बैठ रहे हैं सो मोस्टली सर डेली वेजेस जो नहीं होता है, कॉन्ट्रेक्चुअल डेली वेजेस टाइप के सब बैठ रहे हैं।
देखिए समझ में तो सब आ रहा है, लेकिन बहुत ज्यादा इस डे में करना भी बहुत मुश्किल है। अदरवाइज क्या होगा कि मतलब वी आर नॉट द इन्वेस्टिगेटिंग एजेंसी, राइट, वी आर नॉट द इन्वेस्टिगेटिंग एजेंसी, लेकिन कभी कभी कुछ चीजें इतनी स्ट्राइकिंग होती हैं, और खास तौर पे जब अर्लियर बेल इसी ग्राउंड पे रिजेक्टेड है, then ultimately it will come to this only, that the submission was not correct, right? Maybe that I grant him bail on custody, that is a separate thing, what I write in my order, but ultimately they are making a very serious allegation on you that the submission was not correct.
Entire actually कभी-कभी हम बीच में कभी-कभी किसी केसेस में सब चीजों को लाते हैं, हम लोग भी सफर कर रहे हैं। हम बहुत पहले काउंटर फाइल किए थे जिसमें इसी तरह का 2 क्रिमिनल एंटीसीडेंट मिला था।
should not accept the complaint. मेरा suggestion. अगर इस case से changes in the case diary and the
नहीं इस केस में नहीं
should not be filed.
नहीं
Should not be accepted.
नहीं वो कैसे कंपेयर करेंगे? सपोज दैट हमारे पास एक चीज कॉपी दिया है,
जो चीज कॉपी मिलता है आदमी फाइल करता है, whatever report has come,
But that has to be corrected in the actual sense कि case diary में क्या आया, उसमें क्या है, एक verification हम लोग की तरफ से भी हो सकता है। That's the one.
आपको लग रहा है कि कितना वेरिफिकेशन करते हैं?
ये जो बोल रहे हैं हम इनका
हम लोग का एक और चीज है,
रजिस्टर तो कर ही नहीं रहा,
अब
उसको पता ही नहीं अपना एंटीसीडेंट के बारे में।
पैरानेट में लिखे हैं ये चीज।
यानी हम लोग अपना प्रिकॉशन क्या लेते हैं? देखिए जो डायरी हमको दिया गया, लाके का फोटो स्टेट दे दियो, हम लोग एक लिखवाने का प्रयास करते हैं कि आप लिख के दीजिए कि आप जो सबमिट कर रहे हैं सो दैट इज करेक्ट। तो हम अपना सुरक्षा चाह रहे हैं,
इसमें लिखा ही रहता है स्टेटमेंट मेड इन द काउंटरफेट इज ट्रू टू वन नाउ।
और बहुत सारा चीज हम लोग
क्रिमिनल केस करने के लिए एक्यूज के एंगल से सोचना पड़ता है, ठीक है? अब प्रोसिक्यूशन का हाल आप देख ही रहे हैं, वो दिन दूर नहीं जब इनको एक्यूज बनाया जाए, वो दिन ज्यादा दूर नहीं है when they will also be an accused in a case for tampering with the evidences. कितना सीरियस
मोटा मोटी 90% केसेस में होता है जो टेम्परिंग विद एविडेंस से कहा जा रहा है ना।
बस यही मनाइए कि अभी हम बेल में ही बैठे चलिए। टेम्परिंग विद द एविडेंस, एक्यूज का अगर आईओ से फोन पे बात हम लोग ऊपर कर लेना, जितना भी फोन है, तो एक और कहानी शुरू हो जाएगी।
थाना में सीसीटीवी फुटेज कैमरा नहीं लगाया जा रहा है, गवर्नमेंट कई बार दिया, कैमरा को खराब कर दिया गया लोग से। अब हम लोग भी बच बचा के ही चलते हैं, लेकिन नहीं होता तलवार की धार पे चलना हम लोग।
चलिए, heard the learned counsels appearing on behalf of the parties. The learned counsel for the opposite party has himself pointed out certain mismatch in the counter affidavit, in the supplementary counter affidavit, in the counter affidavit filed by this case. In para 12 of the counter affidavit, it has been mentioned that in para 38 and 34 of the case diary, the IO has described that through, isko quote kar denge. The IO has said that there are 282 crime links and 10 FIR against the mobile/SIM found and seized from the accused person. And while giving the criminal antecedent report at annexure A, he seems to have verified only 3 crime links. The needful has not been done by the investigating officer. By the investigating officer of the case. This assumes importance in view of the fact that earlier bail application of the petitioner was rejected by recording a submission of the state that 10 FIRs have been found to be registered against the petitioner.
That is described in para 33.
On the basis of para 33 and 34 of the case study. The IO, it appears that the IO is not doing the needful in terms of the orders passed by this court. The SP of the concerned district is directed to file an affidavit in this case. And the affidavit should clearly state that as to what, with respect to the 10 FIRs, which is mentioned in the portal, with all its FIR numbers. September, post on 9.
Supplementary list for Finance Act number 1 for supplement 164 of 1025.
In this case, today I am filing the appellate memo on behalf of the respondent with 24 votes.
I can.
There is also one idea for deletion of name of appellant number 2 during the pendency of this year expired, and since she has been having the principal of the school, so only deletion is required because appellant number 1 has been made in charge of the primary as well as secondary.
आपको आइए पे कोई ऑब्जेक्शन? आपका वकालतनामा दे दीजिए ना? वकालतनामा filed on behalf of respondent number 224 has been filed during court proceedings, which is taken on record. आइए पे कोई ऑब्जेक्शन?
आइए कॉपी कम
By name party बना दिया, उनका डेथ हो गया. He was the principal of the school. IA number 11319 of 2026 has been filed for deletion of the name of appellant number 2. The learned counsel for the appellant has submitted that the appellant number 2 has expired on 27/26 and he was made a party in the suit as a principal of the Vani Vidya Mandir within bracket primary school. And after his death, appellant number 1, principal of Vani Vidya Mandir High School, has been given the charge of the school with effect from 10/8/2026. Considering the learned counsel for the respondents has no serious objection so far as the prayer for deletion is concerned, in view of the amendments made in the interlocutory application, the appellant number, IA number 11319 of 26 is allowed, and appellant number 2 is directed to be deleted from the cause title in writing during the course of the day. चलिए
इसको नेक्स्ट वीक रख दिए थे, मेरे पास तो कॉपी भी नहीं है, मैं भी कॉपी
नहीं
कल रख दिए थे, कल रख दिए थे,
कल क्यों रखेंगे?
आज तुम लोग, मेरे पास तो प्लेट का कॉपी भी नहीं है मेरे पास. इसको
they are executing the decree or lordship, when in that executing mode also we have brought to the notice of them that is first appeal is pending, it is pending for final disposal, then also they did not appear. Today when the matter is finally going to be heard, now they are appearing and taking
only one day.
अरे भाई एक दिन में नहीं खत्म होगा, इनको प्लेन रिटन स्टेटमेंट पढ़ने दीजिए, फर्स्ट अपील है.
मेरे पास कॉपी नहीं है,
कोई बात नहीं, ये दिन को इनको जरा दिखाइए,
तुरंत नहीं हो पाएगा.
सॉफ्ट कॉपी खोल दीजिए वहां पर. लेट अस सी व्हाट ही इज आर्गुइंग, व्हाट इज द मैटर अबाउट. और कल तो फर्दर कल नहीं हो पाएगा. लेट मी जस्ट टेल यू, टुमारो सेकंड हाफ थोड़ा दिक्कत है, नहीं हो पाएगा कल, लेकिन थोड़ा सा देखते हैं. लेट अस सी व्हाट इज दिस केस. बताइए, आपसे इतना जूनियर लड़का बहस कर रहा है, आप उसको अपोज कर रही हैं, बात सही नहीं। अपोज
मैं अपोज कहाँ कर रही हूँ?
ठीक।
हम तो prayer के लिए भी
What was the suit for?
Suit was for declaration of lawful authority of Jan Seva.
Before Lordship starts the argument, as respondent number one, Lordship, I am supporting the case of the plaintiff.
Very good. At the outset, the learned counsel, appearing for respondent number one, has submitted that he is supporting the case of the plaintiff, of the appellant. And plaintiff is the appellant before this court.
No, we are the defendant.
What happened
Oh,
in this
you are
case,
the
Lordship?
defendant.
Just I'll give the background. But एक minute लाएगा. Why I am supporting? Because it will be very, because I was the plaintiff, supposed to be plaintiff, but actually the case was not filed by this person. It was filed as an impersonation. Some person filed as a president of the Jan Seva Samiti or from on behalf of the Jan Seva Samiti. And on notice, we came to know that one case was filed against us, wherein the prayer was sought. 3 other persons are there. They are not even the members of that committee. What to talk about the office bearers? And they had filed a suit, wherein they appeared. It was the fault on the part of the defendants at that time that we were not informed. Now, when we came to know in the appeal,
आपका appearance तो record हुआ होगा ना?
नहीं,
Somebody
हमारा
must have
हम
appeared.
plaintiff, we were supposed
you
to be
were
the
the plaintiff.
plaintiff. I was not there. Lordship,
तो
you kindly
आपके
see.
नाम से कोई और फाइल किया
हाँ,
है?
कोई और फाइल कर.
मतलब that वकालतनामा is forged.
नहीं, हमारे नाम से नहीं, हमारे
It is a society.
संस्था के नाम से.
It is a society.
और आप कौन है संस्था के?
प्रेसिडेंट.
आप प्रेसिडेंट
हुआ क्या ना, प्रेसिडेंट के नाम से सूट फाइल हो गया. जब ये अपील में आया तो नोटिस गया प्रॉपर प्रेसिडेंट के पास. प्रेसिडेंट को पता लगा कि अरे एक सूट फाइल हो गया, वो सूट हम जीत भी गए.
आप अच्छा जीत गए,
लेकिन वो मेरा प्रेयर ही नहीं था, क्योंकि वो स्कूल को तो हम ही मैनेज कर रहे थे. 3 आदमी जो और थे, they were supposed to be the persons, not even the members of the society. They want to take over the entire.
आपके नाम से सूट फाइल हुआ.
हमारे नाम सूट फाइल हो गया.
आप जीत भी गए.
लेकिन इनका
एक सेकंड, आप जीत भी गए.
हाँ,
ठीक है. आपने क्या स्टेप लिया? Did you take any step?
नहीं, जीते नहीं हो सो. हमको तो पता
आप जीते चाहे हारे, लेकिन जैसे ही पता चला आपको कि किसी और ने आपके नाम से केस
ये जब
फाइल कर
नोटिस
दिया,
आया हुजूर, तो हम यहाँ अपीयर किए, इसलिए लोग अपीयर नहीं कर रहे थे.
अपीयर
और
करके
वहाँ
आप क्या बोल
एक्सक्यूट
रहे हैं?
जी,
अपीयर करके आप क्या बोल रहे हैं?
हम तो कह रहे हैं कि ये जो सूट फाइल हुआ
नहीं,
है,
ऐसे ओरल नहीं, क्या बोल रहे हैं आप? रिकॉर्ड पे क्या है? फर्स्ट अपील है ना?
तो रिकॉर्ड पे हुजूर हमारा पिटीशन कहाँ है? I am denying the existence which is being filed by them.
See,
Entirely
in
of
the
suit
first
has.
appeal,
हाँ.
either there has to be a petition or there has to be something before the learned court. अब आपका ऐसे खड़ा होकर सबमिशन हम नहीं सुन सकते.
नहीं, हम तो ये हुजूर कहेंगे ना, हुजूर के पास तो हमें कहेंगे कि भाई ये जो सूट फाइल हुआ था, इसकी जानकारी अपील में हमें अभी हुई है.
तो कहाँ से कोई एफिडेविट है?
अब उस पे एफिडेविट डालेंगे, चूंकि
क्या
अभी
डालेंगे? आप डालेंगे मतलब? अभी तो आप सुन रहे हैं इनको, अभी तक आपने एफिडेविट नहीं डाला है.
इस पे अब उतने ही एफिडेविट डालेंगे. These are because everything is on record.
I do not.
नहीं, हम बता रहे हैं जो exhibited
You
documents.
see, if there is just a moment,
Yes.
if somebody has filed a suit
Yes.
in your name, right,
As a president, yes.
as a president, and he was not the president,
Yes.
correct? तो ये जो आपका प्ली है ना, ये प्ली तो आपको वहीं पे नलिटी के लिए फाइल करना है. मतलब कि सूट आप समझ रहे हैं, जो जजमेंट एंड डिक्री हुआ है उसकी नलिटी के लिए फाइल करना पड़ेगा आपको. कि आई एम नॉट द प्लेंटिफ हियर. यहाँ पे बोलने से नहीं होगा.
यहाँ पे इसलिए होगा.
नहीं होगा यहाँ पे.
ये जो डॉक्यूमेंट एग्जिबिट कराए हैं, that document is against them. पहले तो डॉक्यूमेंट्स देखना तो पड़ेगा कि who are the persons, whether they are पार्टी पोजीशन है कि नहीं. ये कर लेंगे, हमको जरूरत नहीं.
ठीक है, आप आराम से बैठिए.
लेकिन
लेकिन आपका ये ओरल सबमिशन
नहीं,
है और
बिल्कुल चलेगा. वो डॉक्यूमेंट से हुजूर प्रूफ हो जाए.
ठीक
इनके डॉक्यूमेंट से प्रूफ हो
वही
जाए.
हमारा केस ही होगा.
प्लेंटिफ के डॉक्यूमेंट से प्रूफ हो जाए.
चलिए देखे ना, अभी इंट्रोडक्शन में इतना लड़ाई. और हमको पता है आपके जो को ओपोनेंट हैं वो लंबा बहस नहीं करते, वो ही विल स्ट्रेट हिट टू द नेल.
This was a suit for declaration of lawful authority of Jan Seva.
Plain. चलिए पढ़िए तो who are the plaintiffs?
Plaintiff number 1 is Jan Seva Sadan, a registered body under the Society Registration Act, bearing registration number 186 of 2003-4, having its office as Chota Kamaria, COPS Kamaria, District Saraikela, Kashama, presented to the plaintiff number 224. Second is Rajendra Mahto. 3 is Chandranath Mahto. 4 is
Vasant Kumar.
Vasant Kumar. Versus Hemnath Mahto, Paritosh Mahto, Judapati Mahto, and Ashutosh Mahto. They have been arranged as principal of Bani Vidya Mandir. 2 was the principal of Bani Vidya Mandir primary section. 3rd was the accountant, and 4 was head of Suraksha Samiti, Bani Vidya Mandir. All are having its office at Bani Vidya Mandir, Chota Kamaria, POPS Kamaria, District Saraikela. Now the suit was for declaration of lawful authority of Jan Seva Sadan to manage the Bani Vidya Mandir and also for handing over the management of the same to Jan Seva Sadan. So this was the suit which
They are just seeking a declaration and also for handing over
the management of the church.
And who are you? You are
We are
the
the
school.
school. Hemnath Mahto, Paritosh Mahto, and Ashutosh.
Third, Ashutosh Mehta is also the applicant.
Also the applicant.
And accountant.
He is performer respondent because he has already retired as per my instruction.
पढ़िए जरा सूट पढ़िए.
That Jan Seva Sadan as well as Bani Vidya Mandir school are situated within the local limits of Gamaria police station and lies within the territorial jurisdiction of this learned court. That subject matter of the suit is management of Bani Vidya Mandir Gamaria, which has illegally taken by the defendants in their hands. That the school, namely Bani Vidya Mandir, has come in operation sometimes in the year 1984, and the school was result of hard labor and work done by the general public of Chota Kamaria village and its Panchayat Samiti. That during the course of time, for proper management and administration of the said school, a committee in the name and style of Jan Seva Sadan was formed by the Panchayat and villagers and permanent Khatyani resident of Chota Kamaria, and the same has been registered before the Registrar Society Registration Act by registration number 187 of 2003-4, Government of Jharkhand Rajya. That Jan Seva Sadan used to look after the administration and management of the school, Bani Vidya Mandir, and running the school swiftly since long, and returns to the effect has also been submitted to the Registrar of Society each and every year. That after enactment of Right to Education Act, some letter was issued by DSC Office Saraikela about the existence of management committee of the Bani Vidya Mandir school, and the letters are received by the defendant number 1 and 2. But instead of informing the matter to Jan Seva Sadan and defendant number 2, concealed the letter for some ulterior motive. That Jan Seva Sadan is already in charge of management of the school, and the defendant number 1 and 2 are duty bound to inform the matter to DSC Saraikela about the fact that school has already got school management committee under Jan Seva Sadan. That after taking opportunity, the defendants in a most mischievous and fraudulent manner created a fictitious body, showing themselves as office bearers of the school to operate the school and taking the management of the school illegally with some handful of interested person in the assets of the Bani Vidya Mandir school. That the defendants, without holding any general meeting with the parents or of the locality, themselves elected a fictitious management committee in the year 2014. In the year of 2014, and in a most fraudulent manner, illegally started taking control of transactions and management in their hands, and also started misappropriation of school funds for their personal gain. That the defendants themselves become head of management committee and manager of Bani Vidya Mandir, be it mentioned herein that on 25/8/2012, while the principal defendants filed a written complaint to Joint Secretary School Education and Human Resource Development Department, State of Jharkhand, Ranchi, themselves admitted that Jan Seva Sadan used to run the Bani Vidya Mandir school Gamaria. That various local public mukhia and members of Jan Seva Sadan had informed the illegal acts of the defendant to Regional Deputy Director of Education Kodhan at Chaivasa, to which the learned RDDE issued a letter number 648 dated 7/10/15.
RDD is who?
Regional Deputy Director of Education. To the defendant number 1 and 2, and directed them to file SOPAs within 10 days, else appropriate action will be taken. That the learned RDDE passed order for fresh election of school management committee in presence of general public, and to that effect letter number 103 6/4/16 was issued by Regional Education Office, Gamaria to the defendant number 1 and 2. That learned RTTE Charibasa further issued letter number 184 Charibasa dated 22/4/16, directing Regional Education Officer Gamaria to conduct election in presence of full permanent member, and several other direction was given in the said letter dated 22/4/16. That in the light of the above noted letter, the Regional Education Office issued letter number 110 to the defendant number 1, 2, 3 and the plaintiff and informed that new committee will be elected on 16/6/2016. That subsequently on 7/6/16, before the general public and in presence of Mukhya and Up-Mukhya of Chota Gamulia Panchayat, a meeting was held and therein Devendra Nath Mahato was elected as president of Jan Seva Sadan, Mahadev Mahato as vice president, Vijo Pada Mahato as secretary, Buddheshwar Sardar as joint secretary, and Mihir Chand Mahato as treasurer. That the management committee for Bani Vidya Mandir School was also formed and total 16 members are elected, namely Chandranath Mahato, Sharad Chandra Mahato from Jan Seva Sadan, Renu Devi, subordinate Mukhya, Asha Mahato, Manohar Mahato, Ranjit Mahato, Khandu Devi, Pinku Mahato, Urmila Sardar, Srimati Santi Sardar, Puspa Kumari Mahato, Bashant Mahato, Anulya Mahato, Sushen Mahato, and the defendant number 1 and 2, being the headmaster, and are also remain as members of committee. That out of them, Amulya Mahato elected president, Sushen Mahato as vice president, Chandranath Mahato as secretary, Ranjit Mahato as joint secretary, and Sharad Chandra Mahato as treasurer for Bani Vidya Mandir School Management Company. That after inquiry made by RTD Kolhan, in earlier complaint, no satisfactory answer given by the headmaster secondary section Mihir Kumar Mahato and defendant number 2, hence directed them to file a point-wise so-called white letter dated 22/9/16. That further notice was also issued on 23/2/2017 by RTD Kolhan for hearing the matter. That finally on 2/5/17, the learned RTD Kolhan directed the defendants and plaintiffs to elect the management committee of the school for the section of primary 5 to 8 standard in presence of regional education officer through general meeting of ex officios, teachers, previous managing committee after dissolving the then body of the school management committee. That even after several directions, the defendants did not bother to stop their illegal acts and continue to hold their post as office bearers, and upon their wish now and then, former several committees and dissolve the same, them elect another one doing mere table work. The defendants are in best position to explain how those table works. That the defendants, after taking the management of the school, started several illegal acts such as false role of DLED training and misappropriation of funds of school, and tried to justify their acts, and due to such reason, Jan Seva Sadan sent several letters to Deputy Commissioner Saraikela Khasama, DSC Saraikela Khasama from April 2018 to August 2018. That the defendants intentionally and willfully neglected the direction made by the competent authority, RTDE, and therefore the defendants are in illegal occupation and change of school management of Bani Vidya Mandir. That the defendants have got no authority to continue with their illegal acts of taking charge of school management. That due to the act of defendants, the general public of locality and each and every member of Jan Seva Sadan suffers with mental agony and disturbance. That in the meantime, on 23/9/2018, the President Devendra Nath Mahato, Secretary Vijo Padro Mahato, and Treasurer Mihir Chandra Mahato, for personal reasons, stepped down from their post, and hence Jan Seva Sadan elected the plaintiff number 2 to 4 as fresh office bearers in their place. That on 2/12/18, Jan Seva Sadan passed resolution authorizing the plaintiff to take proper appropriate legal action against the defendants. Then, in accordance with the resolution, new elected committee submitted information to the regional registrar Jharkhand, Ranchi, and afterwards issued letter to the defendants to hand over the administration and details of the transaction to Jan Seva Sadan within 7 days, by letter dated 7/12/2018. That, however, till 14/12/2018, the defendants did not order to do so, hence this suit. that at present the defendants are in power and possession of all resolution registers created by them, accounts and books and vouchers and other documents, and the plaintiff not able to give complete details of the same. However, the plaintiffs reserve their right to seek details of those documents from defendants at appropriate stage of the suit after their appearance. That the cause of action for the purpose of suit arose at Chota Kamariya within the jurisdiction of this learned court for and from the month of June 2017 and continued and lastly on 7/12/18 when the defendants neither held elections to form new management committee nor hand over the charge of the school administration and management to the plaintiff till 14/12/2018. That as the suit is for mere declaration, hence as per the assets of Vani Vidya Mandir, the suit is valued at 1 crore and fixed court fees of rupees 250 is paid. Although they are seeking handing over the management, but for the purpose of court fees, they are only paying. That in the premises set forth above, the plaintiff prays for a decree declaring that Jan Seva Sadan is rightful authority to look after the administration and management of Vani Vidya Mandir School, Chota Kamariya, for a decree directing respondents to hand over the administration, accounts and all other documents etc. related to management of Vani Vidya Mandir to the plaintiff within 2 months from the decree, for a decree for handing over the administration, accounts and all other relevant documents etc. related to the management of Vani Vidya Mandir School, the plaintiff by process of court by appointing a receiver etc. if the defendants have failed to hand over the same and in accordance with the decree, for a decree for suit of the cost of the suit.
Three questions just taken. When was this society established?
In the year 2003.
The school was also established in the year 2003?
No, it was prior to.
Prior to that. Since when? Because it was being run by this Seva Samiti throughout.
Yes, sir.
So when was this society
Somewhere
established?
in the year, in the plaint have stated somewhere in the year 1984.
1984. And what is the date of registration of this Jan Seva Samiti?
Yes, sir. Date of registration is
Original date of registration.
this.
Initial one.
Initially it was registered.
Parapur, 2003 Parapur of the plain.
Registration number 187.
So school, prior to this, the school was not there.
School was there.
84 से become 84.
84 से तो ये जन सेवा समिति 84 से नहीं था.
नहीं वो बाद में सोसाइटी एक बना उसको फिर मैनेजमेंट फरा दिया.
This is 19th December 2003.
Why these state government authorities have not been made party in this?
That is for them to explain because it
सारा का सारा कहानी उन्हीं का है. वो चिट्ठी दी है, ये किए, वो किए. You know why am I asking these questions? Because under the Societies Registration Act, there were a number of societies which were registered with the state of Bihar. Right? There was a notification issued. Pursuant to that, in the year 2004, a large number of parallel bodies got registered in the state of Jharkhand.
Yes.
And there was no transfer of registration. That ये जो 2003-04 का जो registration है ना, ये बहुत ही fishy registration. Parallel body create करके, मतलब I'm just telling you that this thing has happened. So I just wanted to know when at what point of time this Jan Seva Samiti was originally registered.
originally 19th December 2003.
This is the common case.
Yes, because Lordship, in paragraph 4 itself, Lordship, it is clear. For the management of this school, Lordship, this society was registered. Paragraph 4 specific, Lordship. That during the course of time and proper management and administration of the said school, a committee in the name and style of such and such was formed.
So this
by
is the
Panchayat
original
members.
registration.
Yes.
Right? So there is no such story
No.
that there was an earlier registration and there was a
Several
fresh
cases
registration.
Lordship I have also done. 87
Yes.
का है, 87 का है और फिर दोबारा registration number यहाँ 2002-03 का मिल गया.
और
वो
उसके
बीच
बाद
का gap.
बीच का गैप है और उसके बाद दो पैरेलल मैनेजिंग कमिटी
Yes,
चल रहा है
एक
और
बिहार
एक
वाला
मैनेजिंग कमिटी दूसरा को एकदम
एक बिहार का
hijack
registration
कर
number
दिया.
से एक झारखंड का registration number से. That was the
hijack कर
case.
देते.
Yes. ये वो केस नहीं.
ये बहुत सारे केसेस हुए हैं झारखंड में. I think
Lordship
there
is
are
correct.
numerous such cases and this all happened in the year 2002-03.
जब नया बना था.
They are trying to, but they do not have any document.
They are trying to say this.
They are trying to say that they are the president, secretary, and treasurer of this society, but they have not brought anything. We have categorically
Reading में भी तो
denied that they are the president,
Reading में भी
secretary
नहीं.
You see,
in our WS.
another angle, subject to, we have yet to go into what has been decided. Under the Societies Registration Act, if there is any dispute with regard to management, then there is a particular provision. ऐसा कुछ angle है impugn order में?
No, Your Lordship, that because in the impugn order, the whole issue was not framed whether they are the president, secretary, or treasurer of the society or not. Although this was
The core
specific-
dispute.
Yes, Your Lordship. The sole dispute. This has to be should have been decided first,
Issue was
but
not
no
framed.
issue was framed on.
Although denial
And the
was
order
made.
has been passed that management should be handed over to Jan Seva Sadan. But the issue is whether they are the president, secretary, and treasurer of Jan Seva Sadan or not. That issue was not framed and order has been
So
passed.
they claimed that they are the president, secretary of Jan Sevak Sangh.
Jan Seva.
So they have to prove it
They have to
ex
prove it.
special.
Yes, Your Lordship.
Have
That is
they
not-
proved it?
No, Your Lordship. As per my submission, they have that. Well,
What all documents did they produce?
yes, Your Lordship. Your Lordship, may kindly come to the list of documents.
First, let us see the issues.
Page number 49, Your Lordship, paragraph 12, independent page 50.
Yes.
The following issues were framed in the suit to decide this suit, which is as follows. Whether the suit as framed is maintainable in its present form, whether the plaintiff has got valid cause of action for this suit, is the suit barred by law of limitation, is the suit is barred by principle of waiver, estoppel, and acquiescence, whether Jan Seva Sadan or registered body under the Society Registration Act is the rightful authority to look after the administration and management Vani Vidya Mandir School at Chota Gamali, whether the committee in the name and style of Jan Seva Sadan formed by the Panchayat and villages of and the permanent Khatyani residents of Chota Gamali for the purpose of management and administration of the school Vani Vidya Mandir, whether the plaintiff is entitled for declaring that Jan Seva Sadan being the rightful authority to look after the administration and management of the Vani Vidya Mandir school situated at Chota Gamaliya, whether the plaintiff is entitled for the decree giving a direction to the defendants to hand over the administration account, another document related to management of Vani Vidya Mandir school to the plaintiff, whether the plaintiff is entitled for decree of appointment of receiver by the process of the court for receiving the administration accounts and all other relevant documents related to the management of Vani Vidya Mandir school, whether the plaintiff is entitled for the cost of the suit or any other relief or release.
No issue on court fees.
No issue.
No issue on court fees.
That was
Because
the
they are seeking recovery also, no? They are
Recovery also.
seeking recovery
and
also.
this was also in
It
our
is not a
WS.
mere declaratory suit.
Yes, sir. And our WS, it has been specifically denied that they are the president secretary. And that issue is also not.
इनके डॉक्यूमेंट्स दिखाइए इन्होंने ये जो लिस्ट ऑफ डॉक्यूमेंट्स इन्होंने फाइल किए हैं
Yes, sir.
witnesses तो यहाँ पर हैं
P1 is the registration certificate of
let us have a look at that इनका डॉक्यूमेंट्स होगा इसका एक और वन आप बताइए which is that clinching document which you say that they have not been able to make out their case themselves.
because the documents which they have filed, they are not, their name is nowhere mentioned. And that is a common document. Here also,
Even as a member.
not even as a member. Because section 15 also
Registered
says
secretary.
P1 is the registration certificate of Jan Seva Sadan. P1 by 1. Gives a list of 13 members. They are none of them. P2 is a letter which has been written by Prakhand Shiksha Padadikari to applicant number 1 and 2. That also does not find their name as to so that they are the president, secretary or exhibit 3. Yearly report. There also the name of the other 13 members are there. Their name is nowhere there. They rely upon one letter, exhibit 4. If your lordship make any from exhibit 4.
Yes, I'm just.
This is the document which they are relying on.
Yes.
They are writing a letter to Assistant Inspector General Registrar. Content is a general body meeting of Society Jan Seva Sadan held on
Exhibit 4.
exhibit 4. Yes, P4.
Yes. X1, X2 इतना सारा है.
There are several documents marked X.
3.
Only for identification.
एक क्षेत्रीय शिक्षा उपनिदेशक मिहिर कुमार प्रधान X बहुत सारे डॉक्यूमेंट्स.
X by 1, X by 2, X by 3, answer 2, X 9.
To the Assistant Inspector General Registrar.
Yes, Your Honor.
बताइए.
P4.
हाँ.
They themselves write a letter. And I'm just a general body meeting of Society Jan Seva Sadan held on 10/7/16 under the presidency of Sri Upendranath Mahato, ex-president of society. As per the agenda of the general body meeting, the election of new committee members and unanimously the old body has automatically dissolved, and now office bearers shall perform all businesses including the operation of bank account, and it has been resolved that a new current account should be opened in the State Bank of India, IO Works, account number such and such. Newly elected office bearers and committee members are as follows. Executive committee members as follows, and they gave their names as president, secretary, treasurer. They put their signature and they have only sent it to the assistant registrar. Now this document itself is contrary to their statement made in the plaint at paragraph 26. And beside this, they have no.
Paragraph 26, they have stated what?
Yes, they are saying. Paragraph 26, they say that on 23/9/18, the president Devendranath Mahato, secretary Vijayapado Mahato, and treasurer Mihir Chandra Mahato for some personal reasons stepped down from their post, and hence Jan Seva Sadan elected plaintiff number 2 to 4 as fresh office bearers. Here they say that ex-president is Upendranath Mahato, and when they have been elected as the office bearer, that document is nowhere. And it is a registered society. Not anybody can come and form an association and will say that we have been elected president, secretary.
सबसे इंटरेस्टिंग है नया बैंक अकाउंट भी खोल ले. ये हाईजैक ही करने का कहानी. स्टोरी ऑफ हाईजैक.
So that is the story.
आपके नाम से एक नया आदमी खड़ा होगा. उसके बाद एक नया बैंक अकाउंट खुलेगा. और उसमें उसके
And
बाद सारा पैसा.
next page is the bank account details. And these are the all exhibits which have been filed by them.
Subject to what they have to say, right?
Yes. And their name has also not been registered with the registrar of society. They have not brought that document on.
That's why this is what I am looking for.
section 15 of the Society Registration Act also says that any member will have to will be given a subscription. Nothing has been brought on record as to when they became a member. No check of it.
उसके बाद पुराने बैंक अकाउंट का क्या हुआ?
That is operating.
That is also.
क्योंकि मैनेजमेट इनको मिला नहीं.
And then along with this, they annex this. Minutes of meeting. 10-7. What is this next document after this? 2018 वाला document के बाद? No, I don't get it. You see, they say that the election was held on 10-7-16.
10/7/16.
The election has to be yearly election.
Once in 3 years.
Once in 3 years.
It is for 3 years. It is written in the memorandum itself. समिति का कार्यकाल 3 वर्ष होता है.
और आपका क्या डॉक्यूमेंट है? When were you elected?
No, हम तो प्रिंसिपल.
अच्छा, आप principal.
Principal. They did not
But
make.
according to you, who are the actual office bearers of Jal Seva Samiti?
The list of 13 members which appear in the common list, we are saying they are the actual authority. We have also filed the same document as exhibit. So both of us are relying upon the same documents, same exhibits. And we are saying if they are the members, when have they been inducted as a member? They should prove. They are completely failed to prove that. We are saying that Jan Seva Sadan is there. That is taking care of the school, no doubt about it. But they are not the president, secretary, and press. So they do not have any locus to execute the suit on their.
Did you take a specific plea that they are not the members of Jal Seva Samiti?
Yes, Your Lordship.
Where is that paragraph?
Come to paragraph 6 and 6 onwards. What might have been? that the suit suffers from misjoinder and non-joinder of parties, it is submitted and stated that all the necessary members and office bearers of the institution of Jan Seva Sadan, registration as registration number such and such, has not been made party in the suit. The copy of the real and authentic Jan Seva Sadan was obtained by letter number such and such, registration of the Revenue and Registration Department of dated such and such. The defendant number 4 is not the head of Suraksha Samiti.
This must have been exhibited 19/3/2019 document.
Yes, Lordship, that is
Where
exhibit
is that?
D. Sorry, exhibit DA.
DA.
DA. And in paragraph 10, we have stated that they are beg to submit that plaintiffs are not the authorized and rightful person to bring this suit on behalf of Jan Seva Sadan. Neither the plaintiffs are elected, nor selected, nor nominated for the representative of Jan Seva Sadan. The plaintiff is only in order to capture and to squeeze money. This false and bogus claim has been solved.
DA is again the same document.
Same document.
Registration.
Registration. And the list of members are also there. 13 members are there.
So unless there is membership, unless there is increase of membership,
Yes,
there is no question. If there are 13 members in a particular society, only they can participate
They
in
can
the election.
participate. They are the government.
Unless they are able to produce some document that new members, जैसे कि electoral roll में नाम आएगा तभी आप election के लिए खड़ा हो सकते
That is what it is. Yes, sir. When the members are not there, they cannot participate in the
हैं. Actually, election I card पहले चाहिए, उसके बाद ही आप खड़े हो सकते हैं.
जी, that is. सिविल कोर्ट के वकील फिर यहाँ के प्रेसिडेंट तो खड़ा नहीं होता है, यहाँ के मेंबर नहीं.
और ट्रायल कोर्ट ने क्या फाइंडिंग किया?
Trial court has not, because this issue was not framed. The trial court suppose that they are the president member.
Under the assumption.
Under an assumption and passing. That you hand over the management to Jan Seva.
So this point is not covered by any of the issues.
Not covered by.
If it is covered by an issue, then I will decide it. And if it is not covered by any of the issue, it is something which I have to demand.
The entire judgment which has never
Judgment is one thing. Is it covered under any of the issues?
None of
framed
the
by-
issues are covered. No, none of the issues.
ये एक मेजर प्रॉब्लम है. कोर्ट खुद से कुछ इशू फ्रेम कर लेता है. कोर इशू.
Only on presumption that these persons are the office
Let us see
bearers.
the issues once.
Yes, sir.
Para 12. Para 12. Which? Para 12 means whether the suit as framed is maintainable in its present form, whether the plaintiff has got valid cause of action for this suit, is the suit barred by the law of limitation, is the suit is barred by principles of waiver, estoppel and acquiescence, whether Jan Seva Sadan or registered body under the Society Registration Act is the rightful authority to look after the administration and management, Bani Vidya Mandir School at Chota Gamani, whether the committee in the name and style of Jan Seva Sadan formed by the panchayat and villagers and the permanent Katyani resident of Chota Gamani for the purpose of management and administration of the school Bani Vidya Mandir, whether the plaintiff is entitled for the decree declaring that Jan Seva Sadan being the rightful authority to look after the administration and management of the Vani Vidya Mandir school situated at Chota Mawali, whether the plaintiff is entitled for decree giving a direction to the defendants to hand over the administration, accounts and other documents related to the management of Vani Vidya Mandir school.
ये
and the
issue number 8 से नहीं cover हो.
plaintiff, because plaintiff number 1 is Jan Seva Sadan, there is a presumption. First thing which should have been there that whether
They are the two
office bearers are
office bearers of Jan Seva
Jan
Sabha,
Seva,
which has not been filled,
which has not
although it was directly in dispute.
directly in dispute. In 3-4 paragraphs you have stated that they are not even members.
So your specific cases, they are not even members, so they
No.
could not have been elected.
Yes.
So they have to show their membership
Membership
first.
and
And not only membership, once the member is included, it has to be informed to the registrar society.
Registrar.
He will register it. They have to get the certified copy from
Certified
there
copy
that
and-
they have been introduced as members. That is a procedure. I
Section
think.
19 provides that certified copy can be obtained any time of the school.
सुन लिए रिस्पोंडेंट
हाँ,
क्या
सुन
बोलना
रहे
है
हैं।
आपको?
उसका जवाब देंगे नेक्स्ट वीक।
नेक्स्ट कोर्ट फीस का क्या होगा?
हाँ?
कोर्ट फीस
क्योंकि आज ही वकालतनामा मिला, हम पढ़े भी नहीं है, देख नहीं पाए।
वकालतनामा मिल गया था,
हाँ जी।
क्लाइंट से
हम
राय
मिल-
मशवरा करिए कि क्या करना है।
ठीक, देख
और पता कर लीजिए उनके पास मेंबरशिप है भी कि नहीं।
बिल्कुल बिल्कुल, अगर है तो फिर हम उसको एडिशनल एविडेंस में लाएंगे।
एडिशनल एविडेंस यहाँ नहीं होगा ना, हम तो रिमांड कर देंगे, वहीं पे जाके एविडेंस दीजिए। जो कोर इशू है वो फ्रेम ही नहीं हुआ। You see whether the petitioners, whether the persons who are filing the case are the office bearers or not, that was the core issue. And whether they are members or not. Firstly, whether they are members or not. And secondly, whether if they are members, whether they are the office
Properly
bearers or
elected
not.
subsequently.
Election
these
is-
things are
Whether
not
the issue was raised before the London trial court or not.
It has
Whether
been
there
raised.
is any
WS नहीं ना raise करेंगे और कहाँ से
वही तो
raise
raise
करेंगे?
ठीक है, मेरे पास भी कुछ कॉपी भी नहीं है, इसे हम पढ़े भी नहीं।
पढ़ा दिए।
मतलब नया बैंक अकाउंट भी खोल लीजिएगा। This is too much.
आप लोग डेली झगड़ा देख ही रहे हैं स्कूल में क्या होता है।
वो छोटा सा इशू है, इसको तो
छोटा
डिमांड
सा-
ही करना बच्चे।
देख
कोई
लेते
उपाय
हैं।
नहीं, आपका एडिशनल एविडेंस यहाँ नहीं चलेगा क्योंकि इट इज नॉट पॉसिबल।
नहीं, थोड़ा सा हम भी अपना क्लाइंट से बात कर लेते हैं, लॉर्ड से, इसमें क्या है।
नहीं तो इशू बना के यहीं पे ट्राई कर।
हाँ, और बढ़िया रहेगा। हमको तो लगता है कि इससे ज्यादा हमको न्याय मिलेगा, सभी को मिलेगा।
बढ़िया है, अच्छा है।
हम बढ़िया
हमारा
है।
टाइम वेस्ट नहीं होगा।
हाँ,
Institution
time waste
सब तो
नहीं
rules
My submission was that although they were issue was not framed, but they were very well aware that they have to address this issue first, because in the WS also we have taken the specific pleading and they have adduced all the documents which were available to them.
We did not find any application before the London trial court to framing the additional issue, Lord.
जरूरत नहीं है।
और
Court can
जरूरत
itself-
order for it है।
court can file it even at the time of delivering the judgment. उसके पहले वो issue बना के वो decide कर सकते हैं उसको।
But he
Because
can
all
also
the
file-
documents
he
are
can also file an
readings are
application before the London trial court, Lord.
It is better, Lordship, if not to escalate the matter. The issue can be decided here itself. Lordship can, it is a continuation of the suit appeal. हो जाएगा उसमें बहुत limited point है, इनका कोई document ही नहीं है, that is in my favor.
आपका एक सहारा आप कर ही रहे हो, दिमाग खराब है।
Lordship is doing.
हाँ, लेकिन इनका बहुत लिमिटेड ही डॉक्यूमेंट आएगा। इन लोग को अपना मेंबरशिप का रसीद ही प्रोड्यूस करना।
और सारा इन्हीं का डॉक्यूमेंट हुजूर, हमको कोई दूसरा डॉक्यूमेंट लगाना भी नहीं। नेक्स्ट वीक ट्यूसडे वेडनेसडे कर दी।
हाँ, बिल्कुल।
वेडनेसडे छुट्टी है, थर्सडे नेक्स्ट थर्सडे
थर्सडे का हम लोग कुछ रखेंगे, है ना?
27 को तो रख ली 27th।
इसका क्या नाम नंबर? Heard the learned counsels appearing on behalf of the parties. The learned counsel for the appellant has submitted that the core issue involved in the case was as to whether the persons who had filed the plaint who had filed a suit were the office bearers of the registered society. A specific plea was raised in the written statement that they were neither the members nor the elected body. He has also submitted that unless a person is a member, there is no question of his standing in election of a registered society. And unless the membership was proved by the plaintiff, their locus to file the suit was not proved. The Learned Counsel has referred to the exhibit which has been produced by both the parties. Some of the exhibits which has been produced and relied upon by both the parties, and submit that name of the plaintiffs, the name of the office bearers of the plaintiff as reflecting in the plaint is not reflecting in the list of members of the society. He submits that the issue as to whether the persons representing the plaintiff were entitled to represent the plaintiff was itself not framed by the learned court.
Being a registered.
Being a registered body was itself not framed by the learned court. The Learned Counsel has also submitted that such issue may be framed by this court. An appropriate order be passed to decide the same. Before hearing this case further, it would be important to hear the plaintiffs in this regard. Respondent number 2, 4.
2 to 4. 2, 3 and 4.
2, 3 and 4. And at the request of the Learned Counsel appearing on behalf of respondent number 2 to 4, post this case on Tuesday, the supplementary
Tuesday.
for further hearing.
This Tuesday.
This Tuesday. और कौन सा Tuesday?
उसके बाद थोड़ा सा कुछ डॉक्यूमेंट मंगाना है।
अपना मंगाना है।
मेरे पास कुछ भी पेपर्स नहीं है।
कोई जरूरत नहीं, जो है वही तो है।
मेरे पास वो भी नहीं है।
तो इनको भाई पेन ड्राइव में दीजिए।
हाँ सब।
कहाँ है आपका पेन ड्राइव?
ले लेते हैं।
सारा सॉल्यूशन है।
हम तो सब चीज का गिफ्ट आप लोग के लिए लगे रखे हुए हैं। टाइम के अलावा क्या चाहिए खाली बताइए।
एडजस्टमेंट का बहाना नहीं चाहिए।
नहीं बहाना नहीं करते।
बहाना
नहीं इनके लिए नहीं कर रहे हैं।
नहीं,
हम लोग अपनी बात
as a counsel he is realizing
Yes.
as
He
a
has
counsel,
realized.
but still he has to
Yes.
seek instructions from his litigant.
His appearance has to be justified.
Yes. So इसलिए ये तो
नहीं हम जनरलाइज बोले हुजूर, हम लोग बहाना करते हैं, हम लोग अपनी बात कर रहे हैं। ये कागज चाहिए वो चाहिए तो हुजूर के पास
नहीं, तो जब भी होता है अपना केस करते ही है। टाइम नहीं लेते। ऐसा एलिगेशन आप एकदम नहीं लगा सकते।
नहीं हम अपनी बात कहते हैं। हम लोग
आप टाइम देते हैं। आपका जूनियर आके टाइम देते हैं।
इनको छोड़
सहारा में टाइम मत दीजिएगा।
अभी तो
सहारा बना देंगे।
अभी हम सहारा थोड़ा सा बाहर है।
अब सहारा से बाहर है।
थोड़ा बाहर है।
देखिए
कभी हुजूर क्या होता है ना जब क्लाइंट एडवाइस
अभी तक मेरे दिमाग में सहारा घूम ही रहा है, वो निकल नहीं रहा। That will take, I think,
अभी एक
that would be the one of the toughest case I would have decided so far.
Whenever dispute is by some advice which you want to give to the client, if they do not accept, और लगता है कि अपने अनुसार चलेंगे, then we have to take a back seat.
Permission item 2, WPL 5014 of 2026.
Treated as partners. आई कौन है?
Item 2.
My lord, my senior is in grades on procurement.
इसका कोई time fix नहीं है ना?
हाँ, which this is very short matter. Gratuity, they are admitting, but they are not paying, and the impute order says that there is another dispute which is pending relating to whether he has been terminated or his voluntary retirement has been accepted. So the impute order at page 55 is that this gratuity case will be decided after the decision of the industrial dispute which is pending ID case before
But
labor
is
court.
there any order of?
And they are admitting the
withholding?
gratuity amount. Indeed, they have filed the counter Tata Steel, and they are admitting that they will pay the gratuity amount.
Have
In
they
fact-
deposited it?
They have not deposited. They are, but in the counter they have said that
Who
they
is your
will.
senior?
Mr. Manish.
They have filed their counter. So for almost 3.5 years, his gratuity has not been paid, even though he is.
The order of compulsory retirement has been passed.
The order of compulsory,
What is
he
the
applied
industrial
for, there was a
dispute
voluntary retirement scheme.
Okay.
He applied for the voluntary retirement
That
scheme.
was accepted.
That was accepted.
Yes.
After 1 year, they say, no, you were doing some business. So after acceptance, it was revoked and he was discharged. So they are now saying, we'll pay you gratuity for 1 year more than what I have claimed. I say I had worked only till 2022, but they say that 2022 we have revoked and 2023 we have discharged. So now that part we are challenging whether that is correct or not. For that they are withholding the gratuity also. In the gratuity case, though they say we pay up to 2023, we are claiming only up to 2022. So admitted amount, at least if they want to pay more, then, and now in the counter affidavit they are saying that you give an undertaking that you accept the termination and you take till 2023 in para 20. You give a form, you accept, only then we'll pay. Para 20 of the counter. There is no question of, now they are trying to extract from him an admission to be used in the other case. I will give an undertaking, if I am entitled to less amount, I will refund. They want to pay me more gratuity, but they don't want to pay me the benefits. The whole dispute is that there are some additional benefits under the voluntary retirement scheme which they don't want. For gratuity, in fact, I'll get more gratuity even after discharge, because in para 9 they have admitted, even in the counter affidavit they are admitting, para 20, page 9.
Form I is to be filled by the employee.
Form I is to be filled by the employee, they are saying.
No, that's payment of gratuity and
Yes, payment. But irrespective of form I, now since the case is already registered and the gratuity case is pending, irrespective of whether I make an application, section 7 subsection 1 says that the employee has to make an application, but section 7 subsection 2 of the Payment of Gratuity Act says that irrespective of whether any application is made, within 30 days they are under an obligation to settle the gratuity claim. If the employee is not receiving, then deposit it with the controlling authority. So they should at least deposit what is admitted before the controlling authority, and controlling authority should decide it independently. It is only a question of whether I'll get gratuity till what period.
They want to save on interest. That is the whole purpose.
That
Form
it-
I से आपसे application लेंगे and then they will say that no. Now
Yes.
Form I has been submitted now. So the interest.
Correct. That
They will-
7.3a they are bound to, because that it is not dependent upon making of an application.
There is a judgment also to this effect.
So should
Hum
they
ही decide.
7.3a
हम decide किए हैं.
that irrespective.
Irrespective of it, it has to be deposited
it has
and
to be deposited.
the interest. Payment of
Unless
interest
it is
comes.
deposited, the interest will. If they deposit, then they are absolved of the liability of interest. If the employee is not coming, to take it. But here my case is still pending before the controlling authority. The controlling authority has passed this order saying that I will wait, even though there is no stay by the labor court. Suo moto, they are staying it, even though they are duty bound to decide it expeditiously. It's a gratuity case. The labor case will linger on for several years, just starting because they have done this, and I have challenged it in 282. There was no occasion to pass such an order. Controlling authority has to pass an order and decide. This is, I am only against interim order. The controlling authority is saying that I will dispose it after the ID case. Page 50. Even though there is no stay from any court.
When did you file your application for that? When did you file your application before the controlling authority?
That is filed. In 2023, the affidavit to my application is 14th January 2020, and the case number is.
No, there is no question of any conflict. Why should he pass such an order?
My lady, if that order was GA case number order was, then it won't be an issue, my lady. That order can go, but because the prayer of the petitioner is only to that extent. There is
Whatever he is extent, he has not claimed. It is not necessary for him to claim everything under the sky, whatever he is entitled. He has claimed an amount which is less.
But my lady, my humble submission would be that this court may not pass an order that releases the gratuity.
We are not passing an order. We are just going to quash this stay order. Suo moto stay order.
That much.
The authority, a case has been filed before the authority, right?
That much.
He has to adjudicate as per law. There is no stay order, right? There is no order passed by the employer against the employee.
Absolutely.
So whatever it is, he has to decide the case on merits.
That much I mean agreement.
Only that
But
much.
my senior would be in a better position.
No, I do not know. We are not here to wait for your senior. It is so simple.
If my lady will just pass it over for 5 minutes,
Okay, call him.
he's on legs and court number 10.
Call him. We are waiting for him.
Yes.
And we'll rise only after he comes. Whatever be the
That
time.
matter is-
Whatever be the time.
Yes.
Right? I'm sure the court number 13 will not sit beyond 4:30.
Yeah, definitely.
We will just say that he cannot stay. He has to decide.
That much is not just
Evidence is also taken in the GA case.
Just wait for some time.
From tail list, orders item 1, first appeal 88 of 1026.
Why is it for orders? Yes, you filed your return. Where is the respondent?
Pain for next week. When council has received the rejoinder yesterday. And so Vivek Banerjee is not available. So he asked me to.
Learned counsel for the respondent submits that they have received a copy of the rejoinder only yesterday. And seek adjournment. Post this case on next Thursday. No further adjournment will be granted. उनको बोलिएगा सिविल कोड छोड़ के आना पड़ता है आपको नहीं तो ऑनलाइन भी ज्वाइन कर सकते हैं लिमिटेशन पिटिशन है व्हाट्स अ बिग डील small matter you can join online also
For final disclosure item 2, WPL 787 of 2022.
The reference has been answered against the management. The management has been directed to rectify the date of. It should be admitted facts of the cases that the respondent workman was appointed on 1/7/1980. At the time of his appointment, his age was recorded as 25 years as on 1/1/1980. So correspondingly, the date of birth was calculated as 1/1/1955. He superannuated on 1/1/2015. Just before superannuation, on 6/12/2010, he makes a request for correction of date of birth. That was rejected on 29/12/2014. Thereafter, the dispute was raised. If your Lordship permits me to place the above,
The dispute was raised when?
the dispute was raised in the year 2015. 14 was rejected. It was and dispute was referred for adjudication on 19/6/2015 for the tribunal.
No, it must have been raised prior to that.
Yes, prior to that, but the rejection was on 29/12/2014.
Just prior to his retirement.
Just prior to his retirement.
And then he raised the dispute.
Then he raised the dispute. And
his request was kept pending at your end for 4 years.
4 years. But the fact remains such. All this law is very well settled. But the initial period of employment within first 5 years also he did not raise any dispute. All these service linked documents.
What was the basis of raising this dispute?
Educational certificate.
What education certificate?
Matriculation certificate.
Dated.
That is dated. Here. That is dated 2/7/1961, which was never produced. Now your Lordship.
Just a moment. Dated
2/7/1961.
7/1961. Showing his date of birth as?
His claim date of birth as 12/7/1979. No, I beg your pardon. Yeah, I just said the reverse. Lordship, his matriculation certificate is dated 12/7/1979 and date of birth claimed is 2/7/1961. Now, Lordship, that is 1 year just before he joined his service. So nothing prevented him in disclosing the date of birth. Now, Lordship.
Just a moment. 2/7/1960.
Now, your Lordships, we produced all the service link documents. Exhibit M1 is the identity card register. Exhibit M2 is the identity card. Exhibit M3 is the Form B register containing his signature. Exhibit M4 is the service excerpt which contains his signature. Exhibit M5 is the photocopy of the service particulars of the accused of the workman. Exhibit M6 is the Form B of the different quality where he was transferred. And M7 is the third Form B of the third place where he was posted. All contains his date of birth as 1955 and all has been signed by him and different time. Now the learned code below do not dispute any of these facts. Simply if the Lordship sees paragraph 26 of the award. In fact, if your Lordship permits me to place from paragraph paragraph 24 onwards, if you watch me, that is in view of Hazel also got it. It will be at running page 54.
You read from paragraph.
That's it. Now, after analyzing the oral and documentary evidences of both the parties, it is quite apparent that the concerned workman Ghanshyam Sharma had submitted his matriculation certificate mark sheet original documents to the concerned authority at the time of appointment, and his testimony on the point has not been impeached by the cross-examination. Moreover, it has been apparent that workman has passed his matriculation certificate matriculation examination in the 1979 as per certificate of Board of High School and Intermediate School examination UP issued on 12th July 1979. The certificate of date of birth has been mentioned in that certificate. Date of birth has been mentioned as 2nd July 1961. Further, in the mark sheet, Ghanshyam Sharma, the high school examination 1979, his date of birth has been mentioned as 2/7/1961, and his PAN card, his date of birth is mentioned as 2/7/1961. However, the management produced the photocopy of the identity card register of Kendudi Puderi M1, in which the date of birth of the concerned workman has been mentioned as 25 years as on 1/1/1980, but the management has not produced the service excerpts or form B of Kendudi Puderi without any explanation where the workman was first appointed. Further, in the I-card, the date of birth of the concerned workman has been mentioned as 25 years on 1/1/1980. All other Form B registers of Anushka Koleri M3 as well as the service excerpts of Vasudevpur Koleri Exhibit M4, service particulars of Vasudev Koleri, and Xerox copy of Form B of Vasudevpur Koleri and Goplicha Koleri. His age is mentioned as 25 years as on 1/1/1980. At this stage, it is relevant to mention here the implementation instruction number 76, which is marked as Exhibit W6, reads as follows: Procedure for determination and verification of age of employees. Determination of age at the time of appointment. Matriculates. In the case of appointees who has passed matriculation or equivalent examination, the date of birth recorded in the said certificate shall be treated as the correct date of birth, and the same shall not be altered under any circumstances. Now, in the case Exhibit W1 and W5, it is very much evident that date of birth of the concerned workman, namely Ghanshyam Sharma, is 2nd July 1961. The management has not disputed those certificates before the tribunal. Further, it is a provision of recording the date of birth of an appointee as per matriculation certificate, and there is evidence that the concerned workman had submitted those certificates, but surprisingly, management has not entered the date of birth of the concerned workman on the basis of matriculation certificate. In view of the discussion and as per IA 76 of Tribunal Finds and Holds, the date of birth of the concerned workman, namely Ghanshyam Sharma, is 2nd July 1961 as per his matriculation certificate, and same should be recorded in the Form B register and service excerpts of Ghanudi Koleri of Basta Koleri of BCCL. The next point of consideration is that whether the concerned workman has admitted his date of birth as 1/1/1980 as 25 years as on 1/1/1980 and raised a dispute at the fag end of service. In this regard, it is required to mention that WW1 Ghanshyam Sharma has categorically disclosed before the tribunal that management has wrongly inserted his date of birth as 25 years on 1/1/1980 in place of 2/7/1961, and had submitted his original matriculation certificate, mark sheet, and other documents at the time of appointment, and at the time of same has been returned after verification. He has also deposed that he has submitted representation before the management on 6/12/2010 for correction of his date of birth. So, what should take into consideration 1980 appointment, first representation is 6/12/2010. But the same was rejected and he was forced to retire prematurely from service on 1/1/2015. In cross-examination, he has deposed that he was never aware of the content of Form B register. Moreover, his testimony has not been impeached in cross-examination. It is required to mention that Exhibit W10 is the representation of the concerned workman before the agent Dhanbi Koleri for correction of his date of birth in his service record, and Exhibit 9 is the Deputy General Manager Ghanudi address to Project Officer for sending service records of Ghanshyam Sharma. Moreover, MW1 has admitted in his evidence that the General Manager has recommended the case of the workman for correction of date of birth as per matriculation certificate. At this stage, it is Relevant to mention here, the learned representative of the sponsoring union has relied on a decision of the Honorable Supreme Court reported in 2014 Volume 3 JLR, in which the Honorable Supreme Court was pleased to hold that in the present case, appellant company has failed to show the procedure as laid down in the implementation instruction. It is the appellant's omission and not the inaction of the respondent which has led to the dispute has been raised in the court at the delayed stage. The attitude of the corporation wherein to avoid the rectification of the date of birth, litigation is unnecessarily prolonged just because they have number of resources in their command goes against the grain of equity and duty against the society at large. On the other hand, the management has relied upon the decision of the Honorable Supreme Court in 1995 EIR 1499, in which the Honorable Supreme Court has been pleased to hold that no reason has been
These
given.
are basically the judgments that you are relying
Yes.
upon.
Now, Your Lordship, kindly see the lower court records also for me.
Para 29.
Para 29. Now, the matter, there is evidence of the concerned workman have submitted his matriculation certificate, mark sheet, and other documents at the time of his appointment, and same have been returned after proper verification. But this date of birth has been mentioned as 25 years on 1/1/1980. Moreover, the management has not produced the service excerpts of the Form B register of Kenduadi Colliery, where the concerned workman was first appointed. Further, the concerned workman had raised a dispute after submitting an application to agent Gandhi Colliery on 6/12/2010. So it cannot be said that the concerned workman had raised the dispute for rectification of his date of birth at the flag.
Why did you produce the documents from the place where
So the 1980 records were not available.
What do you mean? Is it your case that the record is not available?
But we produced all the subsequent Form B register which has been signed by him.
No.
But if he has signed his document, maybe there may be a case that he may both ways it will go against. Suppose I don't produce the subsequent.
5 years prior to retirement is not at the fag end.
So I'll show judgment that within first 5 years, if there is an error in recording the judgment, within first 5 years they have to record it. Not sure. Latest Supreme Court says.
See, latest Supreme Court says
That at the
you show
initial.
me the perversity in the impugned.
Yes, I'll show the perversity.
You show the perversity.
Yes. Lordship,
These
you can
findings
understand
are wrongly recorded because there is also a finding that he has said that the documents were produced at the time of appointment.
that is an oral evidence, no document.
What document will he produce to that effect? Did you cross-examine him on that point? Did you produce the original documents?
Lordship, kindly see
Did
the-
you see at the time of appointment, there is a concept of having a medical examination. If
Yes.
there is, so where is that medical examination report?
Lordship, his own disclosures we have brought on record. His own disclosures.
At the time of appointment,
Lordship, subsequently.
but not subsequently. At the time of
Lordship,
appointment. Because everything is boiling down to the initial appointment in the year 1980.
Lordship, it is nobody's
And
case.
admittedly, he had already passed the matriculation examination. So his initial form, where is the initial form?
Lordship, his admitted case is that despite the fact that I have produced the matriculation certificate, at the time, the management wrongly recorded my date of birth at the time of appointment
That's right.
as 25 years.
Where is that form, initial appointment, some form is being filled?
That has not been exhibited.
So that is the main document.
Lordship, but he admits that Lordship pleading, he has himself pleaded that at the time of my appointment, it is not his case that it was rightly recorded at that time and they have subsequently changed it. His case is at the time of appointment, it was wrongly recorded as 25 years on 1960. Now, if your Lordship permits me to place the records one by one. If your Lordship sees the Form B register that is exhibit.
And you have only produced photocopies.
Lordship, वहाँ पे
Where
तो
is the original?
original is there.
No.
लेबर कोड में तो फोटोकॉपी को ही वो लोग
Exhibit होता है.
ओरिजिनल नहीं रखते वहाँ पे record.
रखते नहीं है, लेकिन आप तो प्रोड्यूस ही फोटोकॉपी
produce-
करते हैं.
प्रोड्यूस हम लोग ओरिजिनल करते फिर उसको सही करके नहीं तो लोड कोड एग्जिबिट ही नहीं मार्क करेंगे.
तो
जो
ये लिख
original
रहा है कि
produce
खाली
करते हैं,
फोटोकॉपी है.
इसलिए करते पूरा कोलियरी का रजिस्टर एक में रहता है. अगर
नहीं,
एक वहाँ पे जमा हो गया
I
तो
can
सारे
understand that the original is produced
But
and
the original
photocopy
is produced,
recorded.
then only they
Who
mark
has,
exhibit.
who has exhibited that document?
M1,
M1.
MW1.
Let us see.
Yes. Lordship, first come to M3, that is one by one. Lordship, you kindly see MW.
First, I will see your WS.
Yes. Lordship, can you see how WS? That is annexure to the Honorable Ministry of Married of
Annexure. Written statement of management.
Yes.
This is
And it's
rejoinder to the
annexure
written.
to page 33.
Yes. Where is the respondent? Is not appearing. इतना छुप के बैठे हैं कि पता ही नहीं चल रहा कहाँ बैठे हैं।
नहीं, अभी आए।
अभी आए आपकी तरफ से हम ही बहस कर ऐसा ही है हाँ बताइए Yes, tell me.
Lordship, can you see? I'm skipping the first three paragraphs. Paragraph 5 we have taken is the law that application for correction of debt cannot be made at the fact that is very well supported by various decisions of the Honorable High Court and Supreme Court. The concerned employee Ghanshyam Sharma joined the services of the company on 1/7/1980 and as per the service excerpts and in the same service excerpts prepared in 1988, the date of birth of the employee is 25 years as on 1/1/1980, meaning thereby that at the date of birth of the concerned employee Ghanshyam was 1/1/1955 without any objection. The service particulars of Vasudev Kulleri also shows that the date of birth appointment of Ghanshyam Sharma is 1/7/1980 and date of birth as 25 years old on 1/1/1980, meaning thereby date of birth of the concerned employee is 1/1/1955. The concerned employee was transferred to various collieries during his service tenure and Form B was prepared in various collieries wherein his date of appointment has been shown as 1/7/1980, date of birth as 25 years as on 1/1/1980, which shows that date of birth is 1/1/1955. Even in the identity card register, also the date of appointment is shown as 1/7/1980 and date of birth is 25 years 1/1/1980 and I-card issued to the by Kentucky Kulleri also reveals the same position. The concerned workman Ghanshyam Sharma during his long tenure of service, about 35 years, never raised any objection with the management regarding his date of birth, but only to raise an objection by filing an industrial dispute at the very fag end of his service, only to gain undue advantage over some years of service, which is totally illegal and is not entitled to any such relief, such and such. Thereafter, what should rejoinder we have filed? Statement made in paragraph 3 of the union is denied. The concerned workman did not produce matriculation certificate at the time of his appointment. To gain undue favor has come with the available with the management at the time of appointment, so he did not do so. The statement made in paragraph 456 by the union is picked up stories far from reality and truth, and the management has not committed any illegal act of violating the norms. The statement made in paragraph 7, the union is denied, and the workman never approached the management earlier for correction of date of birth, but only to file the application at the fag end of the service carried to gain the favor from the honorable union. It is statement made in paragraph 8 of the union in the Women Services plus movement. Statements made in paragraph 9 and 10 are denied as the management committed no illegality in turning down the request of the workman for correction of date of birth, as the management is well covered by the legal purview and documents. So we denied your motion that at the time of appointment produced.
And who has exhibited all the documents?
MW1 your motions.
Various evidence.
The evidence was in the LCM, so that is not been brought.
Just read the evidence of MW1.
Just look at my depositions. Usually left it in it. Directly, I don't have the deposition. Usually, I have left it out. I have the material exhibits.
You don't have the documents and you have started your argument.
sure,
It means that
the
you have not
document-
seen it. I'm sure you have not seen it.
सुबह में टेबल नहीं छोड़ गया होगा. I was preparing for the file. Because all other exhibits and everything is there with me, but depositions are left it in my table.
अब आधा घंटा बहस करने के बाद हम आपके लिए इसको एडजर्न कर दें.
I had it with me, but
देखिए कहाँ पेन निकालिए इसमें.
just page 58 is the evidence of MW1 and page 61 is the evidence of
MW1 has exhibited all the documents.
all the documents.
But it is not reflecting from his.
Normally, not in the other cases also, they don't. In some cases, they don't even mark it as exhibit. We have said, if the lordship says paragraph 6, paragraph. We have mentioned that it is being marked as exhibit, but that portion the presiding officer is required to fill up. They have not filled it.
He says that I know as per records, his age was assessed 25 years as per medical board. Right? He's referring to the record. Where is the medical board?
Medical board is not exhibited in it.
So therefore, this is his specific case that his age was recorded as per medical board. You see, you have an application for appointment, right? A person has to disclose his qualification.
Yes.
If he does not disclose his qualification as matriculate, then you have a medical board, and through that medical board, his age is assessed and it is recorded. He says that as per the records, his age was assessed on the basis of medical board. Where is the medical board?
But that was not exhibited.
So that is why.
But your lordship may kindly see the subsequent
No, nothing. Why did you produce his original?
Lordship, suppose that has not been produced. I'll because that has not been produced, so I cannot say that it is on record.
So it's only on the point of belated.
No, not on the belated. On the point of estoppel also. But he has signed all the certificate, all the forms, wherein the age is disclosed as.
That's right.
Yes.
Belated only, belated application. He is aware that he's on all the records. His date
This
of
is one,
birth.
and secondly, estoppel. If I have not disputed my date of birth in the documents all throughout my service career, from 1988 is the first
This is what is belated.
No, besides belated, estoppel also. Suppose belated means my signature is nowhere in the document. Then belated will be one. Suppose I have been signing the documents without any objection. Suppose my name is Amit
Where is
Kumar.
the signature exhibited?
Yes.
Where is the signature
Document is
exhibited?
exhibited. And
No,
he did
you
not
see, this particular evidence is not referring to any document. How these documents have been exhibited, I am absolutely clueless.
labor
Who
code.
has labor code means what?
Labor code
code
also
is-
has seen the setting of the
No, you
letter has
see,
been
just a moment. The documents are required to be exhibited.
exhibited.
Yes. Where is that exhibited? And when was it marked as exhibit?
But what says I have exhibited it? No, if he has not.
That
followed-
is why we are. After all, we call
Then
for
the
the
thing-
NCR for what purpose?
So then the matriculation certificate is also not exhibited. Matriculation certificate is not.
That is exhibited.
That is also not the same.
That is exhibited. You want to see? I'll show you. What is the name of the employee?
What's the name of the employee is Ghanshyam Sharma. So his deposition is at page 61. If you want to see. Can you see? I was presently I was a permanent employee of BCCL. It is not. It is more so that I was appointed in the said management on 1/7/1980. At the time of joining, I had submitted matriculation certificate, mark sheet, other original documents concerning the to the concerning authority. After verifying original certificate, the same was returned back. As per matriculation certificate, my date of birth is such and such. It has been wrongly inserted in my that my date of birth is 1/1/1980 in case of 2/7/1961. In the admit card register and service excerpts of BCCL, this is positive cases. My date of birth was mentioned as 25 years as on 1/1/19 in the service excerpts as well as the. And the said employer had handed over the documents, and after obtaining the documents in question, I have reported to the management in writing to rectify my date of birth, but the management deliberately did not done so. He admits that later on also, 2010 was the first representation. That it is very material to state that the management of BCCL has inserted in ID card of Ghanshyam Sharma as 25 years on 1/7/1980 and had also written in the admit card register of Kendra Colliery BCCL as 25 years as on 1980. It is a fact that aforesaid management has not stopped at one point. Rather, the management had written in Form B registered 25 years as on 1/1/1980 and also written the service excerpts of Ghanshyam as 25 years as on 1/1/1980. All documents have already been exhibited by the court long before.
Where, in which colliery he was appointed?
He was appointed registrar. It has come. Kendua di colliery.
Kendua di colliery,
Yes.
right?
So he says also the written Form B registered on 25 years such and such. All the documents have already been exhibited by the court long before. That the date of my retirement is not on 1/1/2015. As per matriculation certificate, it is more so that the management of BCCL illegally and arbitrarily retired from my service on 1/1/2015. That at this time the photocopy of the representation given by me to the agent of Gandhi Colliery on 6th May 6th December 2010. It is more so that it is receiving copy of the representation given by me
for rectifying the date of birth. I have called for the same by filing a petition, but the management failed to file the original before the court. The representation application has been written and signed by me. I identify the same and same has been marked as exhibit. Matriculation certificate has also been taken in exhibit as the same manner as that. So if Lordship that has to be believed, then our documents have also to be taken into consideration. Or else Lordship entire matter has to be remanded back for proper marking. And it is his positive case that at the time, despite his cases, I produced my matriculation certificate, but it was not mine. Now kindly see the cross-examination. I joined first at Kendwadi Colliery on 1/7/1980 in Form B register. My signature and photo appears. I was not aware of the contents of the Form B. His signature is there. Form B of Kendwadi, I was transferred to Ankusha Colliery. Form B of Ankusha Colliery, my signature is there, but I did not know the contents of Form B. From Ankusha, I was transferred to Basudev Colliery. Register of Basudev Colliery is exhibit M6. Signature marked as X is not my signature. Of only one he is saying. Ghanshyam is written on the documents marked as 2 Form B signature. I accept. The third I doubt. Exhibit 4 signature marked Y is not my signature. For the first time, I raised the dispute regarding date of birth in the year 2010. It is not a fact that I am deposing falsehood. So he admits some of the signature, he says some I doubt, then he says I deny. So if he admits his signature, then he had an opportunity to say barely by saying that he says I am a matriculate, and barely by saying that I do not know the contents, this will not suffice the purpose.
So that's all.
Yes, I have to rely on some of the judgments. First judgment is 2020, volume 3 SSC, page 411. But should we kindly see para 7 the facts of that case? The fact that the respondent had joined services of the applicant in 1982 is accepted position, though the respondent relies on the matriculation certificate which indicates the date of birth stated therein is 21/1955. There is no material on record to indicate that the said document was produced before the employer at the time of joining the employment. In the background, the service record maintained by the applicant by disclose the date of birth indicated in the document is 4/3/1950, which has been furnished by the respondent himself at the relevant forms under his signature contain the said date. So here also he admits not even if it ignore the denials. Though the counsel of the respondent contended in that High Court had noticed certain alteration in the date of birth as indicated in Form B, the relevance of the document cannot be considered without reference to other documents of the service record. The very fact that the respondent, through his representation made in the year 2009, was seeking for change of entry of date of birth will indicate that what was contained in the service record is 4/3/1950, which was the position from.
He was scheduled to retire on 31/3/2010, and he raised the dispute in 2014.
He was.
Read para 13.
Yes. Just para 8 also not sure.
You have read it numerous times. You come to para 13.
Yes. In the other hand, the instant case, the date of joining is also in the year 1987. The respondent had an opportunity to fill up the nomination form, rectify the defects if any, had it para 13 only not possible.
Yes. It is only after more than 30 years from the date of his joining for the first time in the year 2009,
yes,
he made the representation. Further, the respondent did not avail the judicial remedy immediately thereafter.
yes.
Before retirement, instead the respondent retired from service on 31/3/2010, and
Yes.
even thereafter the repetition was filed only in the year 2014, that is after 4 years from his retirement. These are peculiar facts of this case.
Further, can you permit me?
And he had an opportunity to rectify also, which he did not avail.
Yes, so here also Lordship, they had an opportunity to rectify. Every time he has put his signature, whenever he was transferred, he admits in his cross-examination. First he was appointed in Kendwadi, then Anus, and everywhere he has put his signature.
Now you were saying that there is a recent judgment that 5 years is not sufficient.
Yes, Lordship.
Which is that judgment? That even if it is raised within 5 years, it has to be treated as fag end of service.
Yes, Lordship. Even it has been stated that even if they have good documents to prove his date of birth, but at the fag end it can.
So fag end is a very vague term. You say that it has
five years. Initial 5 years they have to raise that.
No. It is one thing to say. It is one thing to say that dispute has been raised at fag end of service.
Yes.
And it is another thing to say that he has to raise that dispute within 5
Yes,
years.
there is a
Failing means there is an stop.
Just finding out.
Yes,
Just there is a judgment. I have brought it also.
And is there any circular to that effect?
No, there is no circular. This honorable court said that within reasonable period, but it should not be more than 5 years. I'll just point out that. I'll just give the judgment and in the meantime I'll show that part also. Paragraph 12 of this judgment. Paragraph 12. Be it as it may, in our opinion, a delay of over 2 decades in applying for correction of date of birth is expressly fatal to the case of the respondent. Here also, notwithstanding the fact that there was no specific rule or order framed or made prescribing the period within which such application could be filed, it is tried that even in such situation, an application should have been filed which can be said to be reasonable. An application filed by the respondent 25 years after his induction in service by no standards can be held to be reasonable. More so when not a feeble attempt has been made to explain the said delay. From 1980, earliest document which we had filed is 1988. There is also no substance on the plea that respondent that since Rule 84 of MP Rule Financial Code does not prescribe time limit within which an application is to be filed, the applicant was
arising out of a writ petition.
Yes, but law is application for date of birth corrections. Even if there is no time frame, after 25 years it was not intended. Here, Lordship, take into consideration 1980 is the appointment, 2010 the first representation he admits after 30 years of his induction. 5 years ago. Another case of this. Another judgment is 2024 SCC on line 491. These arises of an industrial dispute only. Para 24 if you watch. 20 if you watch. Although we have Lordship para 19 onwards, or if you Lordship permits me para 18 onwards. Undoubtedly, the decision on the issue of date of birth is important for the employer as also for the employee. Reference in this regard may be made to the Bharat Coking Code as well as got para 18.
Yes.
Undoubtedly, the decision on the issue of date of birth is as important for an employer as it is for the employee. Reference in this regard can be made to Bharat Coking Code versus Shiv Kumar Dusad as expressed in Union of India versus C. Ramaswamy. The court also ought not to grant any relief even if it is shown that the date of birth as originally recorded was incorrect because the candidate concerned had represented a different date of birth at the time, taken into consideration obviously with the view of the fact that that would be to his advantage. More, the principle of estoppel would come to play in the present case. The respondent number 3, having stated on 27/12/1972, the date of birth was 27/12/1948, cannot be permitted to raise a claim of his date of birth being 12/3/1955, that too on 14/8/1982. That is after a decade, counting from 27/12/1972 to 14/12/1982. We had 10 years old, 5 years old. Even in STC, it is submitted that the applicant requested for respondent was for the document on 12/11/1998. Although we have examined the matter in the lens of fraud as well as in view of our discussions about, the aspect does not merit deeper probe. We leave it at that. For the present, it will be suffice to refer to the pronouncement of recent vintage by this court in Karnataka Rural Infrastructure Development versus T.P. Nagaraj, wherein the earlier precedents of the Home Department versus R such and such, the state of Madhya Pradesh versus such and such, and Bharat Cooking Coal versus Shyam Kumar Singh, 2020 Olympic SEC was considered. Although this court in T.P. Nataraja had looked into the facts therein, the context of Karnataka State Public Servants Determination of Age Act, the principles laid down would equally apply. So far as the change of date of birth in the service is concerned, which is we concur, considering that it has been quoted. Further, in para 21 thereafter, in view of the above, the court find that much delayed disclosure of date of birth on 12/3/1955 by the respondent number 3, coupled with his initial declaration and admitted position, is based on the initial declaration. He has received employment as otherwise based on 12/3/1955, would not have been legally appointed due to being overage. There is no manner of doubt that the respondent number 3, irrespective of his real date of birth, for the purpose of employment and development, cannot be allowed reported rectification.
His initial appointment is in which college? Please let me know.
Kendu College.
Kendu.
Yes, para 29 years, and in his deposition and cross examination, he has stated.
Kendu College. Which is the document relating to Kendu College?
That is not on record. The earliest
No
document.
document has been produced from
No.
Kendu College.
No, but he admits that his date of birth was
That's
recorded.
right.
Yes. No document of Kendudi College has been produced. The earliest document is
your case is on his admission and his case is on your admission.
no. My case is on twofold. On his admission with respect to Kendudi Colliery, and thereafter from 1988 onwards, all the places where he was posted, the Form B registers have been brought on record.
From 1988 on.
88 onwards.
Prior to that, the documents are not there.
Document is not there as a consul, I admit.
So, the earliest document which you have produced is from 1988. And he raised a dispute in
2000, the first representation as per his showing, that also management denied. He said that he filed a petition, management denied to have received it, but 2010 as per his own showing.
No, you have disposed of, you have rejected his application.
His
in the
request
year
in
2014.
2014, but 2010 representation we are not admitting.
Which representation did you reject then?
His claim for rectification of date of birth was done.
Must have been by a representation.
Therefore, we let us take that 2010 only as the date.
So you don't tell us that he did not prove it. Once you dispose of the representation, the representation
his earliest
is
date,
proved.
yes, his earlier date is 2010. So 1988 also, if your lordship take into consideration, then lordship more than 2 decades have crossed. 1988 to 1998, 1998 to 2008, 2010 is the first representation. After 24 years of that entry, followed by all subsequent entries.
We'll hear you on. Yes. We'll
So
hear
should
you
I
on
show the
Monday.
documents?
Sorry?
Should I
We
show?
are already 4
As
minutes is already passed. You want to argue more?
But I'll just show the documents to your lordship. Showing that his signature is there, which he has admitted, and only 5-10 minutes more, your lordship. And one judgment which I am not finding out in my file, I'll show it in the next time. Because it has come out from my mouth, I'll show it to your lordship that there is a judgment.
You see, in all his documents,
Yes.
it has been mentioned original return. In all his documents which have been exhibited,
Yes.
it has been mentioned original return.
Yes.
So he must have produced it. And then the original has been returned
Returned, yes.
after marking the document
Yes,
as exhibit.
that is the procedure I told you, Lordship, but
That's
I
right.
cannot show it.
So let us see what is your, which all documents have you produced?
Yes. Lordship, you can see. Lordship, you kindly come to page 50 first. This is the form we have. This is the relevant portion of page 51 because it is in a long page, Lordship, it has been put in 2 pages. The photograph. Lordship, you see the 4th entry.
No, I'll come to that later. We'll see the documents earlier. On 17/12/2015, it is recorded in the order sheet also that he produced the documents and all these documents were marked exhibit as W1 to W9, right? And when was your documents exhibited?
You'll have to check the order sheet.
24/5/2014.
14, yes.
Right? That order sheet is not here. 24.
So I'll do one thing, work out record, I'll make the pen drive Lordship, so that next day you may not have to look for the dates. I'll give the page number.
No, you keep busy, I don't have any.
Is it Lordship?
You keep busy, but I don't have any other one.
No, I will take it.
No, I will. Don't worry.
No, order
So
sheet.
that order sheet is not there.
That cannot be linked to our particular sheet. The order sheet is the setting officer has signed it here. Lordship.
It is only attested copy.
The officer will have to attest the original.
No, it
And
is.
it is signed by the presiding officer certified to be. I got this certified to be that is.
These originals were not produced.
Rather than without there being a proceeding. Actually, it was exhibited on mostly 12/12/2016. If you watch it.
M1 to M7.
21/12/2016.
M1 to M7, in which documents X and Y are also marked.
Yes. And most importantly, his own iCard is showing that. iCard is the thing they cannot say I don't have any iCard has to be kept by the workman himself. His own iCard has been exhibited Lordships as exhibit M2. That also shows his date of birth as 25 years as on 1980. Exactly. So he was.
His iCard has been exhibited by you.
Yes, we have a copy of the iCard. iCard issuing register. Lordship, it is made in duplicate. One counterfile remains with us. Other counterfile is given so that Lordship somebody makes a enters into the quantity with a duplicate iCard, we can verify it from him.
Okay, continue on Monday.
As well.
The arguments are.
And he has also produced his iCard. So that is exhibit W4.
That is also 1961.
1960. 25 years as on 1980.
1980. The arguments have remained inconclusive. Post this case for further hearing on Monday. Monday नहीं हो पाएगा. Wednesday.
One day is a holiday next week. Wednesday is holiday.
We can post it on 1st of September. We'll post it on 1st of September. After DCS, what do you have to say? That order can sustain. He himself has stayed the proceedings. And why should he? Why should he stay the proceedings?
I'm not the state counsel in this. I'm appearing for Tata Steel. I don't have to defend that order. Our stand is clear. Our stand is clear. We are willing to pay the gratuity. They have to make a proper
the order has to be passed by the authority. We are not here to pass the order.
Yes, sir.
They have challenged this order that it could not have been stayed. There is no question of any stay. They'll pass whatever order they have to pass. Simple. They could not have suo motu stayed the proceedings.
That,
Simple. You have got the stay?
No, I'm serial craving that I requesting for a family there.
This order cannot be, it cannot be stayed like this. Heard the learned counsels appearing on behalf of the parties. This petition has been filed for the following relief. The learned counsel for the petitioner has submitted that a proceeding was initiated under the provisions of Payment of Gratuity Act before the controlling officer, but by the impugned order dated 21/5/2026, the authority has stayed the proceedings, awaiting the judgment of Industrial Tribunal in case number 4 of 2025.
ID case.
ID case number 4 of 2025.
Labor court judge.
The learned counsel has submitted, the learned counsel for the petitioner has submitted that the petitioner was initially given the benefit of voluntary retirement.
Yes, sir.
And subsequently, his order of voluntary retirement was revoked and he was made to, and an order of dismissal was passed.
not immediately. We asked him to rejoin. He did not rejoin.
Okay.
There were disciplinary proceedings, everything. After that, he was dismissed.
And then he was discharged.
Discharged. Ultimately,
And ultimately he was discharged from service.
after disciplinary proceedings, departmental proceedings.
Right, just a moment.
Yeah,
And
sure.
that order of discharge is subject matter of consideration in the industrial dispute. The learned counsel has further submitted that as per the counter affidavit itself, the management is saying that the petitioner has to file an application under Form I, correcting his last date of service in the company as 23/2023, which is the date on which the petitioner was.
My lord, our standing is he has never submitted form.
That's right. He has yet to submit a form.
There is no question of correction.
With effect from, with the responding company, with effect from 21/3/2023, that is the date of his discharge from the company. The learned counsel has further submitted that as per the provision of section 7 with bracket 2,
7.
7 with bracket 3,
As per 2, they have to make deposit.
yes,
Irrespective
7
of
with bracket 2 of the Payment of Gratuity Act, even if a person does not file an application under subsection 1 of section 7, the employer has to suo motu determine the gratuity amount and give notice in writing to the person concerned. However, he has further submitted that these issues may not be gone into at this stage. The petitioner is only aggrieved by the suo motu stay order which has been passed by the controlling authority. The learned counsel for the management has submitted that no application was filed by the petitioner in Form I, and therefore a specific stand to that effect has been taken in para 20 of the counter affidavit. However, he also does not dispute that the adjudication has to be done by the controlling authority and not by this court. Correct? Admittedly, no stay order has been passed by any competent court of law staying the proceeding before the controlling authority to determine the payment of gratuity, for which an application was specifically filed by the petitioner way back in 2023, and the industrial dispute has been raised only in the year 2025.
No, the application was for VRS, not for gratuity.
No.
Yes, there was no application for gratuity.
No, I'm not saying so.
Gratuity case was filed.
The case was filed for payment of gratuity.
I'm sorry.
4 of 2020.
After hearing the learned counsel for the parties and considering the aforesaid facts and circumstances, the fact remains that a petition being GA number 4 of 2023 was filed before the controlling authority with regard wherein the petitioner claimed payment of gratuity, but the learned authority, instead of proceeding further, suo motu stayed the proceedings. This court finds no justification for the suo motu stay order which has been passed, which is impugned in the present proceedings, that is by impugned order dated 21/5/2026. If there is any impediment in the matter of payment of gratuity, by the impugned order dated 21/5/2026, the authority is duty bound to decide the application as per the provisions of Payment of Gratuity Act. Under such circumstances, the impugned order as contained in Annexure 6 cannot be sustained in the eyes of law, which is hereby set aside. This court has not pronounced anything in favor of either party with regard to their entitlement of gratuity.
Pray for expeditious disposal. Pending since 23.
No, that is for the ID Act.
No, not
Here
for that.
also expeditious disposal.
Since the matter before the controlling authority is pending since 2023, the authority is directed to expeditiously dispose of the proceedings as well.
Not a serious threat. Maybe taken up in the next week.
Next week, there is some problem. I may not be available for some a few days. I'm not sure. It will come next to next.
Same prayer at 44.
It will come automatically. See, the list is so long, but आपका क्या था? आपका बैच है? क्या करना है उसमें? सबमिट डिफेक्ट रिमूव कर दीजिए। सब्स्टिट्यूशन फाइल की।
4 में सब्स्टिट्यूशन है और बाकी सब में डिलीट।
सब डिफेक्ट रिमूव हो गया?
हाँ, सब सारा।
सबका आईए नंबर पर है, मतलब फाइलिंग नंबर पर है कि केस का नंबर?
उसमें से 7 से 16 तक एफए नंबर पड़ गया। सिर्फ 4 है, 17, 18, 19, 20 इसमें फाइलिंग नंबर इसलिए कि सब्स्टिट्यूशन नहीं हुआ।
So Tuesday को कर दीजिए सब। Tuesday not on Tuesday, sorry. Twenty-ninth,
Saturday.
उसे छुट्टी करनी। On Tuesday, that is on 1st of September, in the supplementary budget.